Very well. Welcome back, and we continue to update you right here on Weekend Prime. And as had been promised earlier today, we delve deep into matters to do with the DNA. Just what exactly is it, and what are the legal implications if you want to get a piece of that? Are you concerned about your children? How do you go about it? That conversation, we're having it with Ndong Evans, who is an advocate of the High Court and a constitutional lawyer. Ndong, DNA in this country, a lot of people are getting into this space, but if today I feel like I have grievances and I want to go through it, just where do I start from?
I think it all depends with what is the interest of the issue at hand. Mostly it comes out when it is a children's matter, and when one party decides to deny paternity and says, really, I am not the father of this child. I think that is what mostly largely triggers the process. But nothing stops you voluntarily, because then you could actually do it voluntarily on your own and decide that, well, I'm going to undertake a DNA process, even without.
Let me just ask, we are in a marriage, and I have a child, and somehow I'm not so sure. What are the legal bases for me to go do it? Can I do it like many would say, chini ya maji?
No,
or is it a question of I have to go through legal basis and making sure that I go through the court to give me the rights to do it? I need to look for a lawyer, or it's a question of I'm not so sure about this. This kid does not have my ears, their eyes look like my neighbors, and I need to just find out exactly where I lie, whether I'm the father, I'm raising my child, or someone else's child, and I just need to know the truth. So how do I go about it? What does the law say about it?
I think the most fundamental thing, Dennis, in DNA is consent. Because consent is involved, and you see, there are two very important intersecting rights here. You're dealing with paternity rights, but also you're dealing with the question of privacy. You cannot just decide and go undertake a DNA about a particular child, or your daughter or your son, without their consent. So consent is very important. So if you want to do it on your own, then you must ensure that the child that is involved and the other party have given you consent.
So the question is, my child is a minor, my child is an infant. I just need to know whose consent. Because at the end of the day, I consider these to be, the child is living under my roof. What do you mean that I need to go look for consent? From who?
From the supposed mother, really. We say supposed mother because at that point, paternity is actually in dispute. It's very important, because where we have a child, then there are two parents, obviously. And so the other party must be involved. And even in court processes, you cannot do DNA on your own. You must make an application for a DNA test, and you must lay sufficient basis to be able to allow court to warrant that DNA process. A DNA test is a serious matter. And because privacy rights are involved, you can't just wake up and say, I want to do DNA for the sake. You must demonstrate to the court what is called a prima facie case. A prima facie case is that you lay sufficient basis for the reason you are doing this DNA. Let's say you are suspecting, that the child is not yours. Once you convince the court, and the most important thing where children are involved is the best interest of the child. It's not even about the two parties. You may desire, to undertake a DNA test, but the court may tell you, no, in this process it's not warranted because the best interest of the child is not guaranteed.
What convincing do I have to give the court at that point? If I am, because there are other people who say the kid needs to look at me. What if I am as dark as under the bed, but the kid is as light as the day?
That cannot be a sufficient reason. Cannot be a sufficient reason, because if you want to do DNA for your kid because you feel your kid is light and you are darker, that cannot be sufficient basis. It is not about what you feel. It is about the best interest of the child. For instance, where the custody and maintenance of a child is in contest, in such a scenario, Dennis, it is about the best interest of the child, because the findings of the DNA will automatically make a determination and determine whether the father or the mother is going to take care of the child. So it's about the child. It cannot be your own suspicion where you just suspect that, this child is not mine, really. It must be about the child. It must be about maintaining the child. It must be about custody of the child and somebody to take responsibility. The best interest of the child is number one.
Is number one.
Yes.
Okay. So
that is the sufficient.
So here's the question where right now I suspect that these process through the court would not be is not as transparent transparent because I have my own suspicion about the justice system, right? But unbeknownst to my partner, my wife at that point, I took samples unknowing to them that I know the DNA and what it says. But I decided to go through the judicial process just so the justice system can confirm that the results that I already have. Is that permitted under the law?
It is actually permitted. What parties do is you can do your own DNA test, so that when you eventually present your case before a court of law and the results is opposed to what you actually found when you did your test, then you give the court an opportunity as an impartial arbiter to then go ahead and say, we hereby order now what is called a court-ordered DNA process. One that is overseen by the court, one that is basically undertaken by the court on their own motion. That one will be considered independent. But the only reason why, the only way or the only reason why you are able to draw the court to do that is when you tell the court, I have my own independent, and I do not accept this report. Then the court will then undertake an independent DNA test.
But now there is a crisis in this country, whichever you want to look at it. Not everybody in this country is clean, because there are those who have gone through the DNA test. They have paid those laboratories that are taking these tests just so they get a negative result, so that at the end of the day, when the result is negative, the court would say there is no case to answer. The mother of the child should take responsibility, or the converse could also happen. I need a positive result so that this man to take care of this child. What happens in such a case?
Now that is an ethical, these are now ethical questions that we are grappling with.
But do you agree it happens?
It does happen. It does happen many times, because the reason why it does happen, you see, Dennis, the question of paternity almost conclusively determines on who is supposed to take responsibility of the child. So if the man feels like he wants to go all the way and ensure that the other party takes responsibility, then such unethical things happen. But luckily, that's why I said, whenever you feel or you are not satisfied, with the process that has been undertaken in terms of a DNA test, you can actually move the court to do an independent determination. Such ethical issues can be avoided, really, and most parties do that by having their own process first before they approach court, so that you then get a basis to tell the court, well, we do not trust this matter. People go all length, whether it's mothers or fathers, largely because once you have been found that you are not the father, you have no responsibility, or you have been found that you are not the mother, you completely have no responsibility over that child. Unless you yourself, because there are two ways in which you can become a parent. You can become a parent biologically by DNA proving that you are the father or the mother of this child, or by acquisition, where you decide that this child, although the mother came with them, or the father came with them when they're getting into this union, yes, you have recognized and assumed responsibilities. And there is evidence, for instance, that, you've been paying school fees, you've been you took out a medical insurance of this particular child. In such a case, even if we do not undertake a DNA test, you will still be recognized as a parent.
Here's a question where matters to do with paternity, maternity of a child is something that is a question in many households today, right? And it's a question that anyone would ask. Now that I have to go through all this lengthy process, is there a day that maybe policy would change and this is made mandatory? Once a child is born, DNA is taken, so that from the word go, from the hospital beds, from the maternity, who the parents are?
Definitely. There are a few Scandinavian countries, Dennis, where DNA tests are mandatory. But I don't think as a country we have reached that point. The reason why we have not reached that point is because I think our legal systems have put DNA to not be an automatic question because of other rights that are involved. For instance, privacy rights. You see, you are going to take data and very sensitive data for that matter, very sensitive data. You're going to take blood samples, you're going to take whether it's the hair or which other samples. Those are data protection issues. And because they are data protection issues, they cannot be allowed to be, open-ended. But I think the day our systems work, we will have DNA as a mandatory procedure as within other Scandinavian countries.
And yes, indeed, we look forward to that day when that would happen, because yes, it is a sensitive matter that needs to be addressed. Evans Ndong is an advocate of the High Court.